All right, good morning. It is 10 o'clock. It's Monday, August the 12th. It's the Tennessee Auctioneer Commission meeting. We'll call the meeting to order. First item is a roll call.
Thank you, Chair. Jeff Morris.
Here.
Randy Lowe.
Here.
John Thorpe.
Here.
Ronnie Collier.
Here.
Adam Douglas Lewis. He is absent.
Four members are present. We do have a quorum. Next item is notice of meeting.
Notice of the August 12th, 2019 meeting of the Auctioneer Commission was posted to the website on August 5th, 2019.
All right, thank you. Does anybody have any changes to the agenda before we vote on it? All right, I'll entertain a motion. We approve it as written.
Move we adopt the agenda as written.
Commissioner Morris moves. Commissioner Collier seconds. Any discussion? All in favor say aye.
Aye.
Any opposed? No. Motion passes. May minutes. Anybody got any questions on the minutes? Any
Move we adopt
corrections?
the minutes as written, Mr. Chairman.
Motion's been made to adopt as printed. Is there a second?
Second.
Second by Mr. Lowe. Any discussion? All in favor say aye.
Aye.
Any opposed? No. Motion carries. Appearing before the board, Tennessee Auctioneer Association pertaining to new laws.
Representative here.
Anyone here from the TAA?
We're here, but we're just watching.
Okay.
Fair enough.
All right. We'll move right along to Education Review, North Georgia School of Auctioneering.
All right, great. As you know, we had quite a few more courses this round, so I put it on a grid for you so we can keep track of all of it, and then we'll just have one document, and they're in sequential order, so we should just be able to move right. One thing I'd like to discuss before we get into it was just process. Rule 160-3-04, and as it pertains to CE qualifying programs, says this: the program is conducted by an instructor, discussion leader, or lecturer qualified in the opinion of the commission by either education or experience or both. So, since it's the opinion of the commission, that can also be delegated to other folks on the commission, so long as those folks are commission members. And what we've done with other boards, land surveyor, appraisers, to avoid delays in approval, so we're not waiting to each meeting, something to consider is that we would have one or two designees to approve as they come in, then present to the board as a report, basically to make it all official. But they would have an education review committee, that could be commission members or someone else designated in the opinion of the board to make those determinations, and then you could just approve the report as one report. So I don't know if that's something the commission would want to consider, or if we just want to watch the volume, the incoming volume, and then make that determination another time. But that would be something that we could consider down the pike. Unless there's any discussion in regards to that, we can just move on to the report itself. All right. The first one up we got is.
Want to consider doing that, or do you want to just, because we're only meeting once a quarter?
I don't care either way, but
I didn't think we had any problems in the past.
All right.
I think the full board needs to review it when it comes up,
All right.
in my opinion. But
Very well. To the report then. The first one we have up is North Georgia School of Auctioneering, Selling Real Estate at Auction by Charlie Gay. Let me get there. Got a couple comments on that one. This is one of our approved providers. We are just looking at this course based on the requested hours that they're asking for. They're saying 6 to 8 hours on this one. I think the issue was they have 2 hours of Georgia law. I don't know, I mean, if you want to count that as CE or not for Tennessee auctioneers, but it's still an auctioneer course, but I don't know that it would necessarily meet the standard of the board. That would be up for the board to decide, though.
The 6 to 8 is the 6 without the
That's
other
correct.
2.
Yes, sir.
Talk about the 6 hours, the 2 of Georgia law. I don't think we have anything to say about that. I would say we could vote on the 6-hour course in itself, my opinion.
Well, from a practical standpoint, we only require 6 hours of CE anyway. So it's not like no one would be penalized if either way.
All right, what's the will of the commission?
Make a motion that we approve it.
Motion's been made to approve North Georgia School of Auctioneering's request for continuing education course approval. Is there a second?
That be for the 6 hours or the 8?
For-
the 6.
6 hours, correct, Randy? Just the 6 hours. Is there a second to that?
What could you do, like, if you did the 8, because a lot of guys have Georgia license? I mean,
It wouldn't count for us, but it'd count for
us,
them. I mean,
but I
that's,
mean, all we
that's the
just
only
need
one it
votes
needs
is
to count
6,
for
right?
anyway.
It would have to be approved by the Georgia Commission
Okay.
then, so they would just settle that with them.
I'll second Randy's motion.
Second's been made. Any further discussion? All in favor of approval, say aye.
Wait a minute. So he's got 2 hours of selling real estate at auction, 2 hours of contracts, and he's got 2 hours of Alabama auction rules and law for the 6. Where's the other 2 hours?
It was Georgia law. That's
We
what
got
we had.
Alabama law and Georgia
Mhm.
law, but he ain't
Yeah.
got that. But you only got 4 hours of.
I believe it's in his timed outline. Let me go there. Yeah, it would be in his timed outline. He didn't break it down for you, but he's got Georgia law in there.
He's got right here. He's got selling real estate at auction. 2
Alabama
hours.
auction rules.
Alabama auction rules and law 2 hours, and auction contracts 2 hours. That's only 4 hours of applicable time towards Tennessee.
That's Alabama's. That's what he submits to them, or their application. Yeah.
Where is it for us?
Go to page 7, and then he gives a breakdown there.
That outline,
Yes, sir. It's 8 hours there.
implied warranties, which is not spelled right. What's 8,300 reporting forms?
That would be basically Georgia, their forms.
Anything to do with what we're talking about. That's what I'm trying to figure out. You got 1, 2, 3, 4, 5.
Just misspelled.
I guess that who may bid would count as the 6th hour.
Georgia, that would be the 4 to 5, and then the 11 to 12 are your 2 hours for Georgia.
Okay, all right.
Yeah, and then Alabama. That's since he's also got this approved in Alabama. He's showing their breakdown what they approve. So they
Okay,
approve 6
all right.
hours.
I'm ready.
Say aye.
Aye.
Okay. Motion passes. Nashville Auction School.
You're looking at several courses there. Of course, we have a representative here as well if you had any questions. But I trust that you've already looked through these and are prepared with any of the questions that you may have.
Since they're here, if one of their representatives would just come up and just kind of explain the difference in the courses that we've got here, then that would be helpful. Not to put you on the spot or anything.
I'll give it my
Russ.
best shot. How about that?
Go ahead, Ressa, if you I think they just want a summary. Is that right, gentlemen?
Yeah.
Of each of, okay.
Okay. So we have submitted, one of the things that, let me give you some background information if you don't mind.
Name and who you.
My name and everything first. Yes, my name is Ressa Hansen. I'm the Executive Director of Nashville Auction School in Tullahoma. And with the new law change, what we have spent an inordinate amount of time on is going through the language of the law and overlaying that with our curriculums, both for our 85-hour program and our longer in existence. And as a result of that, in our estimation, in reviewing transcripts, course modules, and curriculum content areas, what we have identified is we have identified some educational gaps. At the same time, we want to be in a position to address any educational needs that may be coming up for licensees that are currently licensed in the state of Tennessee as the rule process proceeds. So we are not being so presumptive to assume that the rules are going to go in a certain direction, but because the commission only meets quarterly, we wanted to make sure that we had programs written, presented, and submitted for approval and review. One of those programs is a 2-hour continuing education program specific to the new law changes, because we felt that it was in the interest of any licensee in the state of Tennessee to laws are changing that may affect how they bring in an affiliate auction, their auction business, and so forth. And that could start immediately with or without a rule process. So that is one of the courses that is submitted for you. We also have submitted a basic 50-hour course. Our course is more than 50 hours, but it meets and exceeds the 50-hour requirement of what we have ascertained would meet the legal definition of basic fundamentals of education and fundamentals of auction education. Submitted a 15-hour public automobile auction course that would be offered online so that those people who wanted to pursue a public automobile auction license would have an avenue to do that. One of the things that has been a factor for the last 10 years since that law came into effect is asked to make has been an issue for people who have been wanting. Generally, we've been able to pull one together by keeping a running list of interested candidates and then working with them to come up about once every year to year and a half. But being able to put that online in a relatively short period of time would make that. Oh, okay, I'm sorry. And then we also have developed, I think, we've revised our basic 85-hour program to cover some of those identified shortfalls that we identified earlier. One of the issues that we deal with is we are the only auction education provider in the country that is approved for every state that requires auction education. So we have multiple state mandates, and so we have overlaid our curriculum with every state and with what we interpret the law to be asking for in Tennessee. And so that has required us to make some modifications to our basic education program. They're minor modifications, but what it does is it allows us to split out that bid calling element so that we can still meet the educational needs for candidates from other states. It allows us to separate out the 16-hour basic fundamental course for someone who just is seeking a bid caller's only license, and to separate out the 50-hour for someone who is seeking a Tennessee license that doesn't want the whole bid calling experience with that. So those are the modifications that we have made to the 101 program. We have submitted those modifications for review. And then we have also drafted an 8-hour course and a 22-hour course that we are calling GAP courses. By our estimation and carefully reviewing all of the educational transcripts and going back through our student rosters, we identify approximately somewhere between 55 and 60 affiliate auctioneers that are licensed in the state of Tennessee or still within their expired grace period who may come up short for meeting the education that would be required to get that full 50 hours. And we also have identified somewhere around 75 potential non-auctioneer firm licensees and gallery licensees, and I know y'all are going to take that up later, that have had the 30-hour qualifying education program, but may, if they decided to advance to a principal auctioneer's license, need additional education. So we identified 6 hours for people who have been through the basic 85-hour program as a deficiency, and we identified 20 hours for people who had been through the 30-hour program as a deficiency. We added 2 hours to that because we felt that if a student was going to come back and get additional education, that it would be a good time to educate them in the law changes as well. So I have an 8-hour gap class that's presented and a 22-hour gap class that is presented. So hopefully between all of those program presentations, we can meet educational needs as they might arise between now and November.
Thank you so much for that. I wanted to understand the differences in the programs, and you did a great job. And we appreciate what all y'all do at National Auction School and the fact that y'all are here in Tennessee and the great job that y'all do. So with that, I would make a motion to approve all the courses from National Auction School.
Motion's been made to approve National Auction School's request on all courses.
Just for the sake of the record, let me just list those courses. Basic and Fundamentals of Auctioneering, 16-hour bid caller certification, 22-hour Principal Auctioneer Gap course, 8-hour Principal Auctioneer Gap course, 15-hour Public Automobile Auctioneer, Auctioneering 101 Revised, 2019 Law Update and Review, and Ethics and Escrow.
Which is a CE class.
Second the motion.
Second's been made. Any further discussion on this item? All in favor say aye.
Aye.
Any opposed, no. Motion passes. Tennessee Auctioneer Association.
All right. That'll be on our iPads as well. Let me skip past these courses, get to where we need to be. I'll tell you what page here in just a second.
Basically, a course with Trey Morris and Peter Garris for the upcoming November convention, which is, for all y'all know that it's going to be moved up, so which is good. We'll be able to come here and do this the day after we cover the convention. So
it's one that, as you noted, that you recognize. You've seen these come here before.
Exactly.
Yes, sir.
They're both consummate professionals, and they'll do a good job. And I make a motion we approve the course.
Second.
Motion's been made, seconded to approve the TAA's request. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. Motion carries. Big Column Boot Camp.
That will be near the end of our presentation here, and that will be page 61. And of course, you saw these in advance, so this isn't anything new, just here for your reference. Unless anyone has any questions, we can move one way or the other.
I think he has 2 different courses that he's trying to get approved.
Big Column 101 and Auction Online Auction 101.
16-hour course for Big Calling 101.
3-hour course for Online Auctions 101.
Interesting to see what they're going to cover in 3 hours. But would that, I guess that would count as continuing education?
That's correct. Yes, sir.
Classroom course. So you have to attend his facility to take that course.
That's correct. Mm-hmm. They're both
Motion that
classroom.
we approve those 2 courses.
Motion's been made to approve both Big Column Boot Camp courses. Is there a second?
Second.
Second. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. Motion carries. Director's report, budget report.
All right. We're We only got it looks like the last 3 months to look at. Recently, at the last meeting, we covered the prior fiscal year reserve balance, administrative cost backs, and monthly expense report through March. We noted the reallocation of legal costs that were distributed back to our program on November and December of this fiscal year, which resulted in notable increase in operation expenses for those 2 months. We already covered some of that, just giving you a quick review so to kind of set up for the last 3 months. We also noted the legal cost backs for February. If you recall, that was mostly due to litigation work done by our attorneys and a formal that we were working on as well. They settled one formal and worked some old cases as well. At this meeting, we're only going to be looking at April through June, the end of the fiscal year. In June, you will note an increase in expenses in comparison to the previous months, primarily in technology and legal cost backs. When I unpacked that a little bit, it looked like that was due to new functionality in Core that rolled out, primarily due to the new license types. We've had a lot of work to accommodate those new license types. Well, one, to create a bid caller license, and to also make those adjustments in our other licenses as well, according to the public chat. You're going to see a lot more, an uptick in expenses there, both for legal as well. Ms. Matlock, as you know, has been working on the rules, also fielding any inquiries that may come in as a result of the new laws as well. And so we're going to see an uptick there. Now that should taper off as we make our way through that transition. But right now, that's why you see a deficit in June. But if you'll notice the 3 months prior, we're tracking right where we need to be. I didn't see anything in there out of the ordinary. If you look, everything is pretty much on par and consistent in its trending, in both our revenues and our expenses. But just to give you a snapshot total, looks like yearly we had expenses of revenue rather of $200,800 and expenses of $189,000, which gives us a surplus of $11,600 to add to the total surplus of roughly $470 something thousand, somewhere in that change. About $473,505 is what's tracking now, but we'll get the final numbers and we'll give that to everyone at the next meeting. Do we have any comments? It's nothing actionable there. That's just for your information.
How do we have negative under investigations? Can you explain that?
A lot of times those are adjustments. It's a total share. There's some things that's not specific to auctioneers, and so it's shared across the program. And if it looks like one program was allocated too much, then they make that adjustment there. So that's why you have that line item, or at least the brackets, making a.
Thank you. Any other questions for Glenn? All right. And next item is reciprocal renewals, continuing ed.
All right, according to Rule 163.11a, we just need some clarification for you as it applies to some applicants that we've had based on reciprocity. I'll just read the rule to you. It basically states that, well, it does say this: the Commission will deem a licensee to have met the continuing education requirements provided herein if the licensee provides to the Commission prior to the expiration of the license or when applying for renewal a written statement by the licensee affirming the following: A and B, so we're looking at two parts there, that the licensee resides in another state or territory which has been recognized by the Commission as having continuing education requirements, and here's the key, acceptable to the Commission. So we're going to hang on that. That's what we're going to park on that and have that. And that the licensee has satisfied all continuing education and registration requirements of that state or territory. So, the case in point we have here, and the question we want to ask is, as it pertains to Florida in particular, and other states like them who don't have CE requirements, if an out-of-state resident who has received a license by way of reciprocity with us, do they need to take the 6 hours of CE? That's open for discussion because, again, it's having continuing education requirements acceptable to the Commission. So if they've come to us by reciprocity, and now they're renewing with us by reciprocity, would we allow the state that they came in by reciprocity, their laws to apply and accept that for their continuing education? Or we say, no, we want the 6 hours.
I know when I renew in other states, when I'm grandfathered and don't have to have CE, they still make me do CE in their state, even though I don't have to have it in this state. I think if we have to make all the auctioneers, and they're wanting to do business in Tennessee with their
You would
license.
assume that they're a resident out of state. They don't
I
live
understand
here.
that, but they're wanting to do
That's
business,
correct.
through their license, they're wanting to do business in this state. And we require every licensee in this state to get CE.
That's correct.
I think they got to get the CE.
It looks like we have a consensus then. That's all we needed. We just needed some a rendering from the commission so we know how to respond to those.
Anything official?
I don't think so. Just I think that'll get it done. It's already in the rule, so we just need an interpretation from the commission.
That's the way I would interpret that. If all of our guys have got to do CE, then they got to do it as well.
Well, that's fine. All right, moving along then. We'd like to move to gallery transition discussion. As you know, there was a repeal for that provision in the statute in the new chapter, and as a result, there will be some licensees that will be affected by those that were gallery owners but not principal auctioneers. And so I know that there was some discussion about that went into the making of those laws, or the Auctioneer Commission, a task force. And Jeff, I know you're part of that task force. If you would like to elaborate further or give us some clarification on that, we'd appreciate it.
Yeah, I don't know how this got missed, but the task force was very explicit in that those licensees that already had license would be grandfathered, and they would be able to continue to have a gallery license. I don't know who wrote the law, but that got missed some kind of way. And I think that there's going to have to be some cleanup legislation to help get this kind of back on track next session or whenever they can get it in, because I know that there's quite a number of those guys that are affected that we did not intend to affect at all. You know, we wanted them to be able to continue to do business as they've always been able to do business, and so I think we just need to be able to work with the legislature and try to get this, back the way we intended it to be. And like I said, I just think it got missed in the write-up of that.
I don't have any comment other than as it currently stands, as the statute is written, gallery licenses and firm licenses have been repealed. So if an individual were to operate as an auctioneer, they would need to, at this time, obtain a different license within the commission. However, as we stated before, we will work on efforts to remedy the situation. Not sure what that is going to look like at this time, but there are a few statutory cleanups that will need to be made, and I believe concerning this and a couple of other things as well.
Okay, I think we just have to take it on a case-by-case basis, but, I would just try to extend our apologies to those guys and hate that they're in the boat that they're in, but that was not the intent of the task force for that law to be written that way.
Any further discussion? Don't need anything on that. All right, legal report.
Okay, so we only have about 9 matters here for you all. Would you like me to read them, or have you read them? And
I tell you, read.
You want to hear me read them?
Yeah,
Okay.
Sure.
So I'll start with number 1. It's 2019-03-7261. This is going to be referred to as respondent firm. So the first, let me hold on one second. The first 5 complaints are related. So complaints 2019-03-7261, 2019-03-7281, 2019-03-7301, 2019-03-7331, and 2019-03-7361 are all related. So as we go through this complaint, we will be basing them off of this set of facts. If there's anything additional, we'll address them when we get to the others. So complainant is a Tennessee resident. Respondent firm is a licensed auctioneer firm. Also, I'd like to address that this complaint came prior to May 25th. The statute, so that's why it's against an auctioneer firm. Broadly, complainant alleges that respondent firm and respondents 1, 2, 3, and 4 were hired to conduct an auction of cars and farm equipment, but ultimately did not abide by their contractual obligations and defrauded complainant out of the proceeds. Complainant states they were contacted by respondent 1 and respondent 2 of respondent firm to discuss auctioning their cars and farm equipment. Complainant went with Respondent 1 and Respondent 2 on October 22, 2018. Complainant alleges Respondent 2 added an additional phrase to the contract in the advertising section to cover up to $5,000. Complainant states that they did not initial this portion since they disagreed. Complainant details several promises respondent firm failed to keep, including posting certain signs, failure to bring certain signs and parking attendants, and alleges that extensive damage was done to their yard and neighbor's yard. Complainant also alleges that respondent firm agreed to set up a display of automotive parts a week prior to the sale. Complainant states respondent firm did not arrive until the evening before the auction. Complainant states Respondent 1 suggested Respondent 4 call the auction because they knew race car parts. Complainant states, however, they were unaware Respondent 4 was not a principal auctioneer. Furthermore, complainant states Respondent 1 was expired during their auction and was expired from November 3, 2018 to December 4, 2018, which counsel has confirmed is not the case. Complainant also alleges respondent firm subcontracted their auction to Respondent 3 and Respondent 4. Complainant states respondent firm claimed Respondent 3 was a licensed automobile auctioneer, but he was just a general auctioneer. Complainant then states Auctioneer 1 ended the auction after 1 hour. Complainant states respondent firm informed them on November 27, 2018, they were keeping the total proceeds from the auction and has defrauded complainant out of any and all money proceeds from the auction. Complainant also provides a report of respondent firm, Respondent 1 and 2, of property accumulated and alleges without evidence respondent firm has perpetuated a fraud against their unknowing clients. Complainant concludes by stating that they were lied to, misrepresented, and defrauded by respondent firm and respondents 1, 2, 3, and 4. Respondent 2 answered on behalf of respondent firm. Respondent 2 states they and Respondent 1 were contacted by complainant to assist with disposal of complainant's drag car parts, farm machinery, and tool collection. On October 22, 2018, Respondents 2 and 1 evaluated complainant's property, fee schedule, advertisement, and a date. Respondent 2 states that 2 copies of the contract were signed on October 22, 2018, and the contract states respondent firm is owed a minimum of $5,000. Respondent 2 also refutes several comments made by complainant concerning advertising promises and the timeline presented. Respondent 2 states that the clerk supplied for the auction has clerked for over 100 auctions in the last 5 years. Respondent 2 also states that Respondent 3 and Respondent 4 were hired to work for Respondent firm. Respondent 4 began the auction after the terms and conditions were read and few items were sold as complainant wanted higher bids. Complainant 2 and Respondent 1 decided to sell some of the drag cars because of the registered bidders' dissatisfaction of the way the bids were denied. Respondent 2 states Respondent 4 began auctioning drag cars and complainant's friend was responsible for starting and describing cars. Respondent 2 states no cars were sold. Respondent 2 also states little interest was shown for the items at the auction for the prices requested by complainant. Respondent 2 states that allowing the consignor to sell items after the auction slows down is a method respondent firm uses regularly. Respondent 2 states they regret complainant's expectations were unrealistic but could not be met and the area for parking was disturbed. Respondent 2 states this area was chosen and approved by complainant with no input from respondent firm. Respondent 2 states that respondent firm in good faith signed these contracts guaranteeing $5,000 to cover expenses and labor for setting up the auction. Based on the information provided by complainant and respondents, counsel does not find any violations of the statutes or rules. According to the contract provided by the complainant, the contract states a minimum of $5,000 is to be remitted to respondent firm. The Commission does not have jurisdiction over contractual disputes, only conduct specific to auctioneer statutes and rules. Therefore, counsel recommends that this matter be dismissed. My recommendation is dismissal.
Sounds to me like if he's got a complaint, he needs to take it to a court of law in terms of, I mean, I hadn't seen the contract. Was it all to be sold absolute, or did they have reserves on them, or could you tell?
I could not. There was talk about an absolute auction. There was no, complainant alleges that there was discussion of absolute auction, but the respondents refute that. There is nothing in the contract that addresses.
Doesn't say that to be sold with regardless of price, or?
See, hold on. I'll pull it up for you real quick.
Shocked me that they would have a reserve auction contract for drag car parts.
The sale will be reserved with 10% buyer's premium.
It will be reserved?
As will be, and the statute says this, 6, the terms of the sale are to be as follows. Sale will be reserved with 10% buyer's premium.
Reserved? That doesn't make any sense.
But looking at this contract, there is no mention of an absolute auction.
Well, I don't know how to act on this one, so without seeing the contract, that would just be based on the points as mentioned, that this is a civil case, not a commission case. Move we dismiss.
Motion's been made to concur with legal recommendation in 2019-03-7261 and dismiss. Is there a second?
Second.
Second by Mr. Lowe. Any further discussion? All in favor say aye. Aye. Any opposed? No. Motion passes.
Number 2 is 2019-03-7281. This was respondent 1. Complainant is the same from 2019-03-7264. Respondent 1 is a licensed auctioneer. Respondent 1 did not provide a response outside of the response provided in the related complaint. The recommendation is to dismiss.
I move we dismiss.
Motion's been made to concur with legal in 2019-03-7281 and dismiss. Second by Commissioner Collier. Any further discussion? All in favor say aye.
Aye.
Any opposed? No. Number 3.
2019-03-7301. This is respondent 2. The complainant is the same. They're a licensed auctioneer. Respondent 2 is the one that wrote the response for respondent firm, so they submitted that response on. No additional.
Move to dismiss.
Motion's been made to dismiss 2019-03-7301. Is there a second?
Second.
Second by Commissioner Collier. Any discussion? All in favor say aye. Any opposed, no. Motion carries. Number 4.
Number 4 is 2019-037331, Respondent 3. Complainant is the same. Respondent 3 is a licensed auctioneer. Respondent provided an additional response stating they never had knowledge of any wrongdoing or intent to do wrong to any client. Respondent 3 also states they would never risk their reputation as a business owner or auctioneer to be involved in improper dealing. Respondent 3 also states that Respondent firm and Respondents 1, 2, and 4 all did their best to make the auction as best as they could. My recommendation is to dismiss.
Move to dismiss.
Motion's been made to dismiss 2019-03-7331. Is there a second?
Second.
Second. Any discussion? All in favor say aye. Any opposed? No. Motion passes. Number 5.
2019-03-7361, Respondent 4. Complainant is the same. Respondent 4 is a licensed affiliate auctioneer. Respondent 4 did not provide a response outside of the Respondent 2 response in the related complaint. My recommendation is to dismiss.
Move to dismiss.
Motion's been made to dismiss 2019-022-181. Is there a second?
Second.
Second by Mr. Lowe. Any discussion? All in favor say aye. Any opposed? No. Motion carries. Number 6.
Okay. Number 6 is 2019-022-181. Complainant is anonymous. Respondent is a licensed auctioneer. Complainant states Respondent is engaging in unlicensed activities. Complainant provides information for an upcoming auction on March 22nd, 2019. Specifically, complainant states there is no licensed auctioneer, no firm or gallery licenses, no approved signing, false advertising, and Respondent is collecting sales tax without a pay number. Complainant provides no evidence to support their claims. Respondent answered the complaint because they are indeed licensed with the Commission. Respondent states they vacated their previous location on March 1, 2019, and all signage and licenses were removed on March 2, 2019. Respondent states the facts are, to their knowledge, true, but the wrong respondent has been listed, and the complaint needs to be directed to the names provided by Respondent. Council has confirmed Respondent is located at a different address. Council recommends this matter be dismissed against Respondent. However, Council also recommends administratively opening complaints for alleged unlicensed activity to the individuals provided by Respondent. So my recommendation is to dismiss and administratively open a complaint against the unlicensed individuals by Respondent. So what happened here is another entity is basically in the new space, and so they are not licensed.
So the guy moved out and somebody else came in that was unlicensed but they got the name wrong and was
Right, that's
after the
correct.
guy that moved out in March.
Yes.
I'll make a motion to go with council's recommendation on this one.
Motion's been made and seconded to concur with council's recommendation in 2019-022-181, dismiss the case and administratively open a complaint against the unlicensed individual listed by Respondent. Any further discussion? All in favor say aye.
Aye.
Any opposed? No. Motion passes. Number 7.
2019-047931. Complainant is a Tennessee resident. Respondent is a licensed auctioneer. Complainant alleges that on May 24th, 2019, Respondent advertised an illegal bingo playing. Complainant states they have been to previous auctions at the location and bingo is in the process at each auction as far back as 2018. Complainant provided a screenshot of Respondent advertising the auction bingo at 5 p.m. on May 24th, 2019. Respondents answered the complaint stating they spoke to complainant, whom Respondent stated denied submitting this complaint. Respondent states they were contracted by another firm company to conduct the auction at 7 p.m. and the additional firm company requested bingo to be added to the advertisement. Respondent adamantly states they were not involved with bingo, that the other firm company held the bingo prior to Respondent's arrival. Respondent states they have since returned to their auction company and are no longer contracting to work for the other firm or company. Counsel spoke to respondent to confirm these details and obtain contact information for complainant. Counsel was unable to contact complainant. Based on the information provided by respondent and the lack of communication with complainant, counsel recommends that this matter be dismissed. My recommendation is dismissal.
We don't regulate bingo at this commission, so I think we dismiss that.
Got a motion? Did you make a motion, Jeff? I did. Motion's been made to concur with council's recommendation and dismiss 2019-047931. Is there a second?
Second.
Second. All in favor say aye.
Aye.
Any opposed? No. Motion passes. Number 8.
Number 8, 2019-036521. Complainant is a licensed auctioneer firm. Respondent is an unlicensed individual. Complainant alleges that on March 26, 2019, complainant received a mailing stating an auction is to be held on May 4, 2019 at 1 p.m. at a location in Tennessee. Complainant states the mailing did not contain a Tennessee license number or Tennessee firm number. Complainant states this is in violation of the advertising rules and unlicensed activity. Respondent did not answer the complaint. Based on internal research, it appears that respondent's license has been revoked or suspended in several jurisdictions. Furthermore, counsel contacted the location to confirm an auction was held on that date at the location listed in the complaint. Counsel recommends a $1,000 civil penalty for unlicensed activity. My recommendation is a $1,000 civil penalty for unlicensed activity.
That brings up, I get complaints or people calling me about a lot of these companies just fly in and, they set up in a hotel and set up what I call an auction. It's not really an auction, and I don't know if that's one of these cases or not, but it sounds like it is, and they're not licensed in Tennessee, don't intend to get a license in Tennessee, and they're in and out. So as many guys as we can catch, we need to try to. So I would recommend that we make a motion that we approve the council's recommendation and find this company if we can.
Motion's been made to concur with council's recommendation, a $1,000 civil penalty for unlicensed activity. Case 2019-036521. Is there a second?
Second.
Second by Commissioner Collier. Any further discussion? All in favor say aye.
Aye.
Any opposed? No. Motion passes. Number 9.
Number 9, 2019-023971. Complainant is a formal employee of Respondent. Respondent is an unlicensed organization. Complainant alleges Respondent has participated in activities that have resulted in Respondent's revocation of their 501 exempt status and is without a Tennessee tax permit. Complainant also states that Respondent has conducted weekly bingo games in violation of Tennessee gambling laws, but has since ceased since contacted by the state. Additionally, complainant states respondent has conducted 2 auctions without a license. Complainant states respondent has advertised these auctions on Facebook. Counsel reached out to respondent following the filing of this response, and complainant explained to counsel that the respondent is still conducting auctions frequently. This information is advertised on the side of the building, social media, and through paper flyers. Additionally, as of writing this complaint, respondent still has their 501 exemption status revoked. Respondent does not appear to fall within any of the exemptions provided in the statutes. Therefore, counsel recommends a $1,000 civil penalty for unlicensed activity. So my recommendation is a $1,000 civil penalty for unlicensed activity.
What did the auctioneer do to cause that 501c3 to lose their tax exempt status?
It was not the organization lost their status, not the auctioneer. So there are
But he said he participated in activities that resulted in them getting their 501c3 revoked.
Right. Complainant did not specify what happens there, but I would assume that that's
And
outside of
the
my
guy
realm
that filed,
in tax
whoever
law.
filed the complaint used to work for the firm.
That's correct.
But the respondent is unlicensed,
That's
and
correct.
the respondent is conducting public auctions.
Yes.
And you know of at least 2 auctions that they've had.
Correct.
Motion that we make the penalty $2,000. We can fine $1,000 for each activity, and so that would be my motion.
Motion's been made to do a $2,000 civil penalty for unlicensed activity in 2019 023971. Is there a second to that?
Second.
Second by Mr. Lowe. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. Motion passes. Rulemaking.
Do we want to go straight into this? It's going to take a while, or do we want to take a break?
Nobody has any objection. We'll take a 5-minute recess if that's all right with everybody. All right, we'll call the meeting back to order. Here, we are up to rulemaking.
Okay, so before you today, I have a notice of rulemaking hearing package. So we're going to be amending and repealing one rule and amending several different rules based upon the statutory changes that have occurred with the passing of the new public chapter. So if you'll look, we'll start with page 3 of the document. So if you'll see at the top, we've made some changes to 0160-01-.01 to add the word principal auctioneer. And, down below 0160-01-.12 is now affiliates instead of apprentice, and 0160-01-.16 is being repealed. Those were originally rules for non-auctioneer owned firms. So we'll start with the beginning. We have rule 0160-01-.01. It is amended to say duties of a principal auctioneer. We are removing the 1 as if there's a rule that doesn't have a 2 and doesn't need a number anymore. And removing 2 and A and B, as 2A and B addressed galleries and firm licenses. So,
Should that first paragraph have principal auctioneer in the paragraph?
well, auctioneer, as defined in the statute, is principal auctioneer, public automobile
Okay, so you're just
auctioneer,
using the
and
word
bid dealer.
auctioneer as principal auctioneer,
Yes,
by
so-
definition?
It'll encompass all 3, so we're basing off of the statute. So that is the change to that rule. Number 01, the next rule, do we have any questions? If you have any questions at any time, just let me know. Otherwise, I'm just going to keep going. 0160-01-.02 is unlawful rebates. Did a few grammatical changes and then removed apprentice auctioneer license or auctioneer license. Apprentice auctioneer license or. So now it just says real estate license or auctioneer license. Again, that would encompass as auctioneer defined in the statute. Rule 0160-01-.05 is publication of name. That would, we're making changes to number 2, so it will remove of an auction sale by an auction firm not owned by an licensed auctioneer, and changed, removed principal from there, and shall is added. And you'll see that we added some authority, new authority, and took some away. So anytime you see 62-19-125, that was the statute that is referred to the galleries. And since that statute no longer exists, that will be in red throughout the package. So rule number 0160-01-.06 is for dates of examination. Prior to this, it said 90 days between completing the 2-year apprenticeship. I've reduced that to 25 days completing the 6-month affiliate auctioneer licensee requirement. Does anyone have any questions about that?
Where did the 25 come from?
So prior to, it was set 90 days for completing the 2-year apprenticeship, so I reduced it by the amount that we have since the affiliate auctioneer amount has reduced significantly as well.
Pro rate of reduction to that?
Yes. Because if you have to wait 90 days to take a test for something for a 6-month requirement, that's half the requirement.
I see where you're going with that. If I understand this rule. No examination shall be administered to an applicant who lacks more than 25 days completing the 6-month affiliate auctioneer license requirement.
So they can take this test at 5 months and a few days, is that what you're?
No, it's just, you gotta take it.
No, this is saying that you can, like less than 25 days in the 6 months, then they can take. Less, but I'm
In
fine
other
with
words,
25.
within 25 days of their 6 months, they can take the test, is what that says.
I believe so, yes.
I'm okay with that.
So 0160-01-.12.10 covers auction schools. So we will amend that to say as required by TCA 62-19-111. It will count for bid caller, affiliate, or principal auctioneer. We added that and removed the words apprentice or firm license. And so next we have C, shall conduct a minimum of 50 hours of classroom or online instruction, including 16 hours in basic fundamentals and at least 25 hours under the supervision of a licensed auctioneer with at least 3 years of experience. So 50 hours reflects the new change in the statute. We added online as that is required, and we reduced 40 to 25 and 5 years to 3 years. D, we removed D as that is no longer required, and then D, E, F, we had some renumbering. Number 2, it pertains specifically to public automobile auctioneers. So we have amended 2C to say, instead of 30 hours, 15 hours of rigorous classroom or online instruction. Those are the changes for the rule for auction schools. Any questions?
The public automobile auctioneer, you just have to have that license just to own the business, and then he can hire anybody that's got a Tennessee license to sell it, right? Is that the way?
For public automobiles, so you have to have a public automobile license as well to do public automobile. That nothing really changed about public automobile auctioneers.
I was told
But I think to Ronnie's point, he's saying he can hire a bid caller to call the sale, but he has to run the auction.
Yes,
I'm
sorry.
not.
Yes.
I'm not an owner of one, but the owner has to have a public automobile auctioneer's license, right?
The owner of a
The auction. Let's just say I own the automobile auction myself. Okay, I've got the public license. John's just a licensed auctioneer. He doesn't have the public automobile auctioneer. Like, can I hire him to come and sell the cars?
yes, but bid callers. I think that
He can hire another auctioneer, or he can call a bid caller auctioneer to call the sale.
What I'm asking is,
But Ronnie, you would contract and handle all the money, but you can hire any auctioneer you want to.
Yeah. that's why I'm asking. I've got the license, but I'm not going to own the automobile auction, so that license is useless to me, right?
My understanding was that from the statutes, and I may be wrong, is that bid callers can call the auction, but you need a public automobile auction to conduct the auction because you also require a motor vehicle license.
That's exactly right.
That did not change.
No, they hadn't changed. In other words, Ronnie, he has the public automobile auctioneer's license.
Yes.
He can contract and handle the money for that auction and hire any bid caller or auctioneer to call that sale.
Yes, to call the sale.
Right.
But he doesn't have to have a public automobile.
No, he does not.
That's all I was wanting to know.
That was the intent of the task force, that guy can call, he can hire 10 auctioneers to call a sale.
I don't have any intentions of owning one, but I've got the license, but it's useless to me. Because all I want to do is work for you in your public automobile auction if you want me to.
Right. Yeah, but you don't have to have that license
Okay.
to go call somebody else's sale.
Rule 0160-01-.11 civil penalties. It removes two sections, specifically TCA 6219-125A and B. Those that statute was repealed. Also, you will see under 3. It also removes TCA 62-19-125A. Any questions there? Okay. 0160-01-.12. It's regarding affiliates, sponsors, and supervision. For this rule, there's basically just a whole bunch of changes from apprentice to affiliate and clarifying that sponsors are principal or public automobile licensees. And it removes removes number 3, which says the number of apprentice auctioneers that an auctioneer may sponsor at any one time shall be limited to 3. That's no longer required. You can sponsor as many as you would like with the new statute. And then it also reduces the requirement from being licensed with the commission from 2 years to 1 year. And change.
And let me interrupt you.
Yes.
I'm not sure that you've got a 1-year requirement for the auctioneer to be licensed to have an affiliate auctioneer in
Yes.
this paragraph. If you go back to 016001.10 auction schools, 1C, under the supervision of a licensed auctioneer with at least 3 years of experience. Is that
This is for teaching.
for teaching?
Yes.
Okay. All right. I was unclear that was for the,
So for teaching, it used to be 5 years, and now it's been reduced to 3.
okay. All right, so he has to be 3 years. Okay. All right. So we'll make sure we were on the same page with that.
Also, you'll see number 10. I deleted the chart. Was not conducive to the rulemaking process. So I put those in the same categories as A, B, C, D, E, F, and G listed there. So that is still the required point system for affiliate licensees to upgrade. Any questions for this rule? No? Okay. Moving to 0160-01-.14. This is regarding fees. Previously the rules were listed in paragraphs. These are now going to be listed in A, B, C, D, E, F, G. We have left the fees, the amount the same, and set a new fee for bid calling auctioneer license that will be set to $150. Also, you will see number 5, previous number 5, the fee for replacement license and pocket card is $35. That's been removed because now we only do replacement licenses, so that there will only be a fee for replacement license, which is $35. If you need a replacement pocket card, that can be printed out online. So no need to charge a fee for that anymore. Next rule is 0160-01-.15. This is regarding non-resident auctioneers. So it says number 2, each applicant for a non-resident auctioneer, and removed the language that's been removed from this is firm license, firm, and signed by an owner or other appropriate member of the auctioneer firm, since that is no longer required. Rule number 0160-01-.20 is the advertising guidelines. So now, number 1, it says that the advertising shall have the name and license number of the auctioneer responsible for the sale, firm, or gallery has been removed. Also, G removes auctioneer, firm, or gallery as well. And number 5. Rule number 0160-01-.21, disclosure of buyer's premium. We removed auctioneer, firm, or gallery in the number 1. Next rule is 0160-01-.22, late renewal of license. We made some clarifying language changes here, so I'll just read through those quickly. Number 1 says a licensee applying to renew a license after the date of expiration, but less than 2 months after the date of expiration, shall pay in addition to any fees required for renewal and satisfaction of any outstanding continuing education requirements, a penalty of $50. Number 2, we removed the word reapply and submit an application for licensure for clarifying purposes, and also satisfy any continuing education requirements. Number 3, we removed 2 to 1 year. We reduce it to 1 year. So if your license has been expired after 1 year, you shall submit an application for licensure and satisfy any outstanding continuing education requirements. Number 5, it says a licensee delinquent in the renewal of a license for 1 year or more shall reapply for licensure and satisfy all requirements for obtaining such license, including but not limited to reexamination and reapplication. So that is just for clarifying purposes. Typically, when a license has expired past 1 year, individual will retest and reapply, but that was not very clear in the rules, so I added that language there.
So as I understand it clearly, up to 2 months after the expiration, they just pay a late fee and they're good.
Yes, that's correct.
All right. Between 2 months and 1 year, what happens?
Between 2 months and 1 year, between 2 months to 6 months, you submit an application, complete your CE, and pay a penalty of $150. 6 months to day 364, you will submit an application, complete your CE, and pay a penalty of $200. After 1 year, you are required to
Start all over again.
Start all over.
Okay. Okay.
0160-01-.23 is retirement of license. We just have 2 quick changes of removing apprentice to change to affiliate. 0160-01-.24 is notification of change of information. So number 1, we have changed that to affiliate, and this removed number 2 because that regards to firms and that no longer is applicable. 0160-01-.25 is regarding public automobile auction and public automobile auction license. We have changed number 1C to be reduced to reflect the correct statute, which is B2, and it is no longer 30 but 15 hours of more rigorous classroom or online instruction. 0160 0-1-0.26 is the escrow account requirement. This was previously for auctioneer firms and galleries, so now it states that all principal auctioneers shall maintain an escrow or trustee account for all funds that belong to others coming into possession as a result of an auction sale. Next is 0160-01-.27 is livestock auction sales. We have changed this to say an auctioneer, 1B, an auctioneer licensed under this chapter, and have removed firm or gallery wherever it is mentioned within the rules, and changed, affiliate, apprentice to affiliate. Any questions there? Okay. Next, we are moving to the continuing education chapter. We'll start with 0160-03-.01. We removed the 1. The change is from C. So licensee for this chapter shall mean any principal auctioneer, affiliate auctioneer, or public automobile auctioneer licensed in accordance with TCA Section 62-19-111. As used in this chapter, this definition shall not include bid caller auctioneers, as bid caller auctioneers are not required to complete continuing education. Rule 0160-03-.03 has basic requirements. We removed a whole bunch of that language, so now number 1 just says all licensees must obtain 6 hours of continuing education per renewal cycle to renew a license. Number 2, we removed sponsor and changed that to education provider for clarifying language, and added the last line, which will say licensee shall also personally maintain proof of completion of continuing education course for 2 renewal cycles. That language is required for our auditing process. If a licensee is, that's something that we are often require from people, so now it's in rules so they'll know to keep up with it. Number 4 and 5 were rules that referred to firms or galleries, and as those rules have been repealed. And then the last one we have is Chapter 0160-01, and that would be the rule itself is 0160-01.16. That rule was previously for non-auctioneer owned firms. That is no longer, this was for gallery and firms, so this whole rule is going to be repealed. So those are the rules. If you have any questions about any rules, I'm more than willing to take any questions or comments at this time.
Lan, I think you've done an amazing job getting through all this and getting it all, dovetailed into the new law, and I appreciate it very much.
So what I'll need following from this rule is I'll need 2 separate votes. I'll need a vote for authorization to submit this to schedule a rulemaking hearing. Whenever we do rulemaking hearings, we have it be the date of the next meeting that will be coming up. And then I'll also need a roll call vote to approve.
All right. First, we'll take up the authorization and to schedule a rulemaking hearing at our next meeting.
Or the meeting after, just in case. But
Or the
hopefully
meeting after.
It'll be one of those 2 meetings.
So moved.
Commissioner Morris moves. Is there a second?
Second.
Second by Mr. Lowe. Any discussion? All in favor say aye.
Aye.
Any opposed, no. That is approved. Now we need a roll call vote on the changes.
Right.
Correct.
Just need a roll call vote then for the changes.
We
First of all, need a motion.
Need a motion second first.
Make a motion.
Jeff makes a motion.
Second.
Ronnie seconds. Any further discussion? We'll call the roll.
Jeff Morris,
Aye.
Randy Lowe,
Aye.
John Thorpe,
Aye.
Ronnie Collier.
Motion passes.
Thank you so much, and we will get these submitted and go through the process of changing these rules.
Thank you. We appreciate you. All right, new business. Glenn?
Just one item that was recently brought to my attention. The commission has the authority to approve qualifying education. As you know, we did that prior in the education review, and CE as well, and to make clarifications as to what constitutes the criteria for that education. One particular problem or situation that's addressed is, as you know, the public chapter requires 16 hours of QE for basic fundamentals. Now, we know of at least one situation where the school has indicated that they would be short based on the affiliate education they've already taken, that 85 hours, that they would be short of that 16 hours. And then, of course, upgrades could be affected as well, but the 16 hours across the board is required for those licensures, whether it's an upgrade or affiliate. So if they've taken, in some cases, if they've taken this 88 hours and the 30 hours, they're probably fine. But those that have only taken the apprentice, formerly apprentice course, in this particular school, or maybe with other schools as well, could be in jeopardy of being short that hours. So if the commission has the authority to qualify what is basic fundamentals and whether or not that transcript would meet that, we just ask that the commission would exercise that discretion in those folks that may be caught in that gap, even though they have an excess of 50 hours, but they might be short the 16 according to the school. We're asking that the commission would exercise their discretion and review those transcripts. Now, I know that might be something you want to discuss, but if not, or a motion in that regard would be required, just to memorialize that, so that we know that is something that the commission would be interested in doing.
Requirement now is 50 hours, and they're getting 80-something hours. They're saying they're still short some basic hours.
Because the public chapter itself says that they have to have 16 hours of basic fundamentals. So it depends on what the school describes or has sanctioned or identified as basic fundamentals. So they've got 30 hours more than the total hours, but they don't, according to the school, would have that 16 hours of basic. So, of course, the commission also gets to weigh in and exercise their discretion to review that transcript if it would be the will of the commission to do that.
Got 80-something hours. I don't know how they wouldn't have 50 hours of basic understanding.
And that would be for the commission to determine. They could look at that transcript and then make that determination.
I would be willing to do that.
We would need a motion in that regard.
Okay.
I'll make a motion that we let that count for the 16 hours. Hours of training.
Is there a second to that?
Second.
Second by Mr. Morris. Any further discussion? All in favor say aye.
Aye.
Any opposed? No. Motion passes.
One clarification, Chairman,
Yes, sir.
if it's okay, if I may. Typically, what we've also had in the past was in some of our other boards, and as you know too, some of that can and has been delegated to administration. If you would like to delegate that to administration, we could take that function on for you, but then of course with advisory capacity of the commission as well. Is that something that the commission would be interested in doing?
I think, too, in clarification of that, I think since all this was done to make getting into the business easier, I think we're going backwards if we don't allow them to go ahead once they've had 80-some hours for that to count. Backing up on what we said we wanted to do to start with.
Right.
Is that a form of a motion then, Mr. Lowe?
Take that in the form of a motion.
Do we have a second in that regard?
Second.
Second.
Second by Ronnie. Any discussion? All in favor say aye.
Aye.
Any opposed? No. All right. Is that all you have?
Yes, Chairman, thank you.
Do you want to do the next?
I have one more thing. Just based on that information, if we could possibly circle back to the sorry, I missed this earlier. The education report, I had a few points that I wanted to clarify with the commission. So currently, we have approved a couple of courses for 6 and 8 hours, but then we have, I wanted to discuss a few of the courses from Nashville Auction School. So we have the basic and fundamentals of auctioneering course. So it looks like that is a QE course that would be the 50 hours that would be required to upgrade your license from affiliate to principal auctioneer. The hours listed here are 51.5 hours. I wanted to know if beforehand, if the commission, that's 1.5 extra hours than is actually required, if that is something that you wanted, if that's something that you wanted to take into account with your previous approval. Because as we were just saying here in our conversation, we want to make sure that we are providing courses that aren't asking people to do more than is required in the statute. So I thought I would just bring that up for further discussion.
I feel like that that if they've whittled it down to that, that they're feeling like that they need that extra time to not skip over anything. I think you're kind of splitting hairs at that point. I think that they've obviously whittled it down from 80-some hours to 51 and a half, and I just feel like that if that's what they feel like that they need to get done with that they ought to be able to do that, and we wouldn't have to try to keep up that extra hour and a half, and that ought to be what that course is, and then if other courses, they would take other courses.
Okay, that is fine. Then I would like to ask about the 85-hour Auctioneering 101 course, as that is now required to be the 50 hours, what the 35 extra hours would be for.
I think that's for out-of-state folks. Is that not right? Am I?
Please.
Thank you. I'm still Ressa Hansen with Nashville Auction School. Commissioner Lowe, to your comments, not only did we compress the 85-hour program, we also compressed the 30-hour program. And historically, if you actually look at what Tennessee Code has mandated since, probably 30 years, has been, in order to be an auctioneer, candidates had to attend at least a minimum of 80 hours of basic education, and then to an additional 30 hours of education. One of the positions that we have always taken is that we view those legislative mandates as a minimum. And we have had to compress not just the 85-hour program, but actually 135 hours of educational content. Those programs had some redundancies, but not complete duplication of content areas. So there were curriculum points in the 30-hour program that were not covered and addressed in the 85-hour program. So that all being said, under the new chapter, there is no bid calling instruction. However, there are still Tennessee candidates for an auction license who still want to receive bid calling instruction. So that Auctioneering 101 program does address the minimum standards for other states, but it also includes bid calling instruction. When we go back to the transcript on the 85-hour program, even though it exceeds the 50 hours, there were significant numbers of bid calling instruction hours in that program that I think put the educational curriculum under the 50-hour requirement if you back the bid calling out. And the code, the chapter is very specific that it cannot include bid calling instruction. So that's
the 85-hour class has roughly 35 hours of bid.
I have it broken out, and if you can indulge me a minute to actually look at that. I've provided all of that to the commission, and
right.
Mr. Kopchak and I discussed it at length as this was coming about. One of the issues that did come up.
Page 38, if you were looking.
Okay. One of the issues that did come up prior to the implementation of this new code was that we had a 30-hour class scheduled in June just before the new code. Have a group of students. We had a group of students who had attended in July of 2017 who were kind of caught in this gap, in this awkward gap. And we still have, like I said earlier, roughly 60 licensees that we know of that have been through national who are still caught in that gap. But the ones with the most immediate issues of an apprentice license or now an affiliate license that is in the process of expiring, needing to make a determination if they to renew their affiliate license, or if they needed to have the additional 30 hours of education. That's when I began working with Mr. Kopchak on evaluating our programs and what we actually covered in the 85-hour that was non-bid calling instruction.
Gotcha.
Versus what was covered in the 30-hour. And that's where we came up with the educational gaps. That's where we came up with the gap courses. So I don't know if that helps to address that, or if that helps legal counsel with addressing the 85-hour 101. But that is specifically to cover the 50 hours minimum. We exceeded that minimum. We always want to give them more than what they have to have.
Well, that is fine, as long as it's clarified to our licensees that 50 hours is the minimum, so the other extra 35 hours in this course is not required for their qualifying education.
Right.
I wanted to make sure that is explicitly clear when people are taking the course.
Absolutely.
A lot of those guys, I will tell you, if having been to school, that's the fun part of the class, you know, and that's what they really want to learn how to talk fast. So that's what that's why they go. And so I think you can make it clear it's not required, but most of them will take that elective position, I think.
As I mentioned earlier, we did have structured our program so that any licensee wishing to opt out can do that without being disruptive to the course or the program. So we have structured the hours of instruction to make that feasible.
So they could take the 85-hour and get the 51 and a half and just opt out of the bid calling.
Absolutely.
So they don't have to come at a different time to make it more.
Exactly.
Okay.
Exactly. And part of also that hour and a half, I do want to also say, includes a non-instructional time, like the orientation and introductions at the beginning of the class, and some time that's built into the final examination.
Gotcha.
So it's not actual instructional time. We give them 50 hours of actual instructional time.
All right. Are you comfortable with that, Anna?
Yeah, I'll circle back in a second.
All right, sounds good.
All right, you don't need anything from us on that? Okay. Anybody else have anything under new business? Sure. Please state your name.
Thank you. Ressa Hanson, Nashville Auction School. I do, because there is so much confusion about the basic fundamentals and fundamentals in the language in the code. I know, because I was also a member of the task force, that the task force did review and kind of differentiate, attempt to differentiate how those hours would shake out. But in this rulemaking process, because there is a chapter in the rules for auction schools, I would ask you to consider maybe clarifying that in that section for us and other auction schools.
Clarify what?
What is the difference between basic fundamentals and fundamentals?
Oh, basic fundamentals and fundamentals? The words are interchangeable, in my opinion. I don't think that on the task force we had any discussion about what the difference between those two words meant.
We did not specific
Basic
to those
instruction
words.
and fundamentals are sort of the same thing as far as we look at it.
So what the conversation we did have on the task force and was drafted was curriculum content areas specific because of that bid caller license and the 16-hour of instruction. What would be considered critical instruction for that license versus the instruction for the additional hours? So that's it was clarified in the task force. It's not clarified in the law. I would like to ask for some clarification. We can look at it as a provider, but as Nashville Auction School, our interpretation may vary from Missouri Auction School, which may vary from worldwide. And how does this commission, or how does the state of Tennessee differentiate that when it actually comes down to it?
We would have to see that language before we could act on it. In other words, to look at a definition, we'd have to have somebody to present us with a written definition that we could compare. I don't know how to.
Also, I'd just like to clarify, we cannot define something in statute by rule. So there would need to be probably, instead of a rule change, a statutory cleanup to clarify what basic fundamentals means, because that based on the varying interpretations that we had. So that is not something that we can necessarily address in rule. It's probably going to be in one of those statutory cleanups that we'll have to address with other parts of the chapter.
Yeah, we got quite a bit of that to do anyway, so I agree with that.
So then, just for clarification purposes for me, as an educator, because we submitted a 16-hour bid caller license curriculum, that's sufficient to meet those requirements at this point that you approved?
As far as I'm concerned, yes.
Thank you.
Anybody else have any new business? Glenn, do you want to present that?
As you know, today is Mr. Collier's last day. Not everyone may know that, but the commission was aware of that. And we just like to take an opportunity to pause and thank him for his service and for his dedication. He's always been faithful to contribute and to add and bring his experience to the table. So that was always very helpful to us. And I know you will fill that position when it's empty, and we all will. And we hope to get somebody with his level of experiences as well. And then he didn't know anything about this, but I've got something for you as well.
All right. I will say while you're doing that, Glenn, that Ronnie has been fantastic on the commission, and we definitely will miss him and appreciate his service to a great deal.
It's been fun.
Let's give him a round of applause.
Thank you.
Thank you, Ronnie.
Yeah, I just say thank you for your contribution to the people of Tennessee.
Enjoyed doing it.
Anybody else have any new business? I'll entertain a motion to adjourn.
So moved.
Second.
Motion been made. Second. All in favor say aye. Aye. We're adjourned.
Can I get a picture of you with your...
Sure.